5 seconds to go. Start. The defendant appellant has raised almost 4 substantial questions of law. Stop. However, this court has raised the following questions of law. Stop. Whether on the facts and circumstances of the case, the lower court has committed error in holding that the will on which the appellant relied on is a will executed by the deceased Diwala Gosha in sound state of mind on 11th January 1975. Sign of interrogation. Whether after the appellate court came to the conclusion that the plaintiff does not prove that the suit properties are undivided family properties and erred to decree the suit of the plaintiff for 1/2 share in the suit property. Sign of interrogation. Here the learned advocate Ms. Dhara Saha for the appellant and Mr. Nagesh Sood, as amicus curiae for the respondent through video conferencing at length. Stop. The facts leading to the present appeal are as under. The plaintiff has filed the suit for partition of the suit properties, which consist of 2 agricultural lands bearing survey number 55, and measuring 2 acres, situated in the sim of village Talsada Khurd, and the agricultural land bearing survey number 30 and measuring acre 3 and 8 guntas, situated in the sim of village Umar Khadi, Taluka Mandvi. Stop. The case of the plaintiff is that the suit properties are the joint family properties of the deceased Diwala Gosha, the plaintiff and the defendant. Stop. It is further case of the plaintiff that deceased Diwala Gosha was the karta of the joint family and Diwala Gosha purchased the suit properties with the aid of joint family funds under the provisions of the Bombay Tenancy and Agricultural Lands Act. Stop. Further, the case of the plaintiff is that the deceased Diwala Gosha died on 13th January 1975. Stop. According to the plaintiff, he had share in the suit properties. Stop. He has also contended that Diwala Gosha was physically and mentally infirm to execute a will. Stop. It is further case of plaintiff that Diwala Gosha has not executed any will and has not bequeathed the suit lands to the defendant. Stop. The plaintiff contended that Diwala Gosha has no right to execute a will. Stop. According to him, yet the suit lands were mutated in the name of the defendant in the revenue records on the basis of the fabricated will alleged to have been executed by the plaintiff's father Diwala Gosha. Stop. It is alleged that the plaintiff had called upon the defendant to partition the suit properties, but the defendant refused to do so. Stop. The case of the plaintiff is that he has half share in the suit properties. Stop. On the basis of these averments, the plaintiff has filed the suit for partition of the suit properties and for possession thereof by metes and bounds and means profits thereof. Stop. It appears from the record that the defendant has filed his written statement at Exhibit 8 before the trial court, wherein, he has denied that the suit properties are undivided joint family properties. Stop. He has also denied that Diwala Gosha was karta of the joint family. Stop. He has denied the contention of the plaintiff that the suit lands were purchased by Diwala Gosha with the aid of joint family funds. Stop.